Hi, everybody. Thank you. Thanks for having me. I'm very, very pleased to be here. Just to repeat a couple of things from my introduction, my name is Jamie Saul. I'm an attorney with McGillivray Westerberg Bender. We're a public interest environmental law firm. We also practice civil rights, open government law, other types of law working for the good guys. We're based in Madison. The topic of my talk today is going to be a relatively brief overview of water law in Wisconsin. And for those of you who hear the word law and just start to glaze over, let your eyes wander to the left, and rest assured it'll be over in 20 minutes. I'm going to talk a little bit today about both water quality law and water quantity law, because I know they're both of interest to many of you. It's hard to believe that 40 years ago, just before we passed the Clean Water Act, we literally had rivers on fire. We had rivers in this country that were so polluted with oil and other chemicals they were burning. And one of the themes I want to convey today is that we've made a ton of progress in that period of time, but that we still have a ways to go. We have, in this day and age, gotten a pretty good handle on traditional types of industrial pollution and toxic pollution that we see coming out of pipes from industrial factories. There are areas of water pollution that we are still struggling to handle, and I want to talk a little bit about some of those today. One of which is, I know, of interest to a lot of us, that's nutrient pollution. Runoff from municipal areas, from agricultural fields that convey nitrogen and phosphorus into our surface waters, contributes to nuisance algae blooms that we see on our lakes in the summertime. So just a very slight overview of the Clean Water Act. The act was passed in 1972, and it generally prohibits the discharge of pollutants without a Clean Water Act discharge permit that we call in Wisconsin a WPDES permit. I know a lot of you have heard that term before. The Clean Water Act makes a really critical distinction between point source discharges and non-point source discharges. A point source is essentially a defined or discrete conveyance of pollutant, like a pipe or a ditch, that can be very easily seen. It can be very easily controlled for its pollution. The Clean Water Act doesn't have a lot to do with non-point source pollution, which we also call runoff. And that's one of the areas where I think in terms of our water quality policy, we're still struggling to create the right mechanism. Most of the nutrient pollution that we're dealing with in Wisconsin comes from non-point source discharges, generalized runoff from farm fields. Wisconsin pretty recently took a really important step in the right direction by passing one of the nation's first numeric water quality standards for phosphorus. In fact, I think we might be the first state in the country to have a numeric standard for phosphorus. It's really sets an important precedent for other states, and it sets the water quality goal for our surface waters. The standard is different depending on whether it's a lake, a large lake, or a small lake, or a stream, or a river. But the water quality standard essentially is the goal for which we are aiming when we issue permits to dischargers and when we set watershed level goals to reduce pollution. That phosphorus water quality standard has opened up a couple opportunities for unique ways to manage discharges of nutrient. And I want to talk briefly about a couple of those. One of them is called adaptive management, and the other is called water quality trading. And I specifically want to talk about these because they lie at the intersection between point source and non-point source pollution. So now that we have this numeric standard for phosphorus in place, the DNR, when it issues WPDES permits, it has to ensure that any discharge from that facility is going to be able to meet the phosphorus standard. This is a big deal for municipalities across the state because they treat a lot of municipal waste that has a high phosphorus content. So they sometimes have to meet a pretty stringent phosphorus standard. At the same time, as I was mentioning earlier, we have a lot of general non-point source runoff that doesn't really have to do anything. So this prompted a conversation driven in large part by municipalities who said, hey, wait a minute, why are you requiring us to reduce our phosphorus discharge to really quite small levels when you're not requiring much of anything from non-point sources? So rather than just griping about it, some folks got together and came up with a couple theories. And one of them is this process called adaptive management that's actually is a part of the Wisconsin's phosphorus water quality rule. And it lets the point source get an extended compliance schedule, sometimes up to 3 permit cycles, which can be 15 years or more, to meet their phosphorus discharge limit in order to use that time to put into place some sort of watershed-based phosphorus reduction. And the theory there is that the municipalities and the other point source dischargers will say, it's cheaper for us to pay some farms further up the watershed to reduce their phosphorus input than it is for us to install really expensive treatment at our treatment plant. Most folks in the environmental community who participated in the rulemaking see this as a win-win solution. I think it's based on the reality that we're a long way from making the progress we need to reduce non-point sources. So by including it in the water quality standard, we rope in the point sources, we bring them to the table, we hopefully get them to pay some money to make some of the reductions happen on their own. So this adaptive management program puts a lot of power in the hands of the point source dischargers to kind of take the lead and hopefully generate some reductions in phosphorus pollution in the watershed. Another method of compliance that is being discussed a lot now is called water quality trading. And the theory there is actually quite similar to adaptive management. You look at the watershed as a whole, and using, again, that numeric standard for phosphorus as the benchmark, you allow the point source discharge to trade pollution credits. We've kind of heard about this theory. You hear about it a lot in carbon dioxide, like trading of CO2 credits, where you kind of set the level and it becomes like a free market mechanism to try to get to that level. And the theory there is that instead of meeting their permit limit for phosphorus, a municipality could go out and buy credits on a market. And the market would be created on the watershed level, and they'd be able to buy credits. And then farmers or other non-point source discharges of phosphorus could generate credits that they could sell by reducing phosphorus on their own in that same watershed. It's kind of an experimental system. It's been tried in a number of watersheds around the country. Wisconsin had I think 3 trading pilot projects in the early 2000s or so that had some mixed success, but there's hope now that water quality trading will help us to get the phosphorus reductions that we need. We also, in terms of implementing the Clean Water Act, there are a few other areas that we're struggling to deal with today. And another one is emerging pollutants. For example, pharmaceuticals. Pollutants that we, until recently, haven't really had the science to understand or even to detect in the water. Now they're starting to show up. And it's typically the case, I think, in water quality policy. The policies and the laws obviously lag behind the science. So as the science becomes more clear, as we start to learn about the source and the effects of pharmaceuticals and other emerging pollutants, we're going to have to get a handle on what can we do to reduce their discharge into our surface waters. I do want to talk a little bit briefly as well about groundwater quality. We've heard a lot about it already today. I know it's on everybody's mind. This is an issue that gets pretty frustrating for me because I actually think we've got a good regulatory program in place, at least on paper, that we should have a handle on this problem by now. We know that there are communities in Wisconsin that have 30, 40%, maybe more of private wells that are unsafe to drink for either nitrate or bacteria. And they're unsafe because they have levels of those pollutants in excess of the enforcement standard that DNR has created. DNR already has an enforcement mechanism in place under the statutes to order remediation of those violations. And it's an area where DNR, I think, has been, for somewhat obvious political reasons, a little hesitant to really engage. So for the communities, especially Central Sands, certainly northeastern Wisconsin, certainly, that have high percentage of nitrate pollution in private wells, we need to discuss ideas on how to engage and pressure DNR to initiate some remediation actions, which it already has the authority to do under the statutes. And I also just want to talk very briefly about water quantity. We have in place in Wisconsin a pretty good public trust doctrine that's enshrined in the Constitution. And it states that the waters of the state are held in trust by the DNR. And it has to manage the water resources for the benefit of all the citizens. We had a recent Supreme Court case, Lake Beulah Management District versus DNR, that reaffirmed the state's obligation to manage the trust, the waters in the public trust for the benefit of all the citizens. But what that decision actually said is that the DNR has a general duty to protect those waters, but it doesn't have a specific obligation to order any steps or to take any steps unless it's presented with specific concrete scientific evidence that the public trust is in danger. So, I see that decision as mostly positive, but a little bit of a mixed bag, because yes, we know DNR has this authority. It's not derived from any particular statutory program. It exists in the Constitution. But now it's been confirmed that the burden is on us as citizens to present that information to DNR as early in the process as we can, so that it has the information available, and that will sort of trigger its duty to take some kind of action. Of course, that case came up in the context of a high-capacity well permit, which is, as I'm sure you all are aware, is a huge issue in terms of how DNR is going to implement that program in the future, especially in light of that Supreme Court case. One thing we're starting to hear from DNR is that, yes, we recognize we have the authority to consider the impacts of this particular high-capacity well, but we don't have the obligation to look at all the other wells, all the other groundwater uses collectively. And that kind of gets to the question of incremental impacts versus cumulative impacts, which I think is going to be critically important. Because we're going to get into, we already are, a situation of death by 1,000 paper cuts. And if DNR gets to the point where it isolates its environmental review to just the impacts of that next well that it's thinking about permitting, then it's not going to get the holistic look that it needs to really make a wise management decision. So we've been working a lot with a variety of groups on pressuring DNR to kind of look at the cumulative impacts as opposed to just the incremental impacts of individual groundwater users. And that came up quite recently in the DNR's revision of NR 150, which is a regulation that implements the Wisconsin Environmental Policy Act. That act requires DNR to do an environmental review of any potential action that could affect the environment. And what DNR tried to do with its recent proposed revisions to the rule is to say we're going to exclude the issuing of high-capacity well permits to farms. We just don't think that's a significant enough of an action that's worthy of a separate environmental review. So on behalf of some groups and some clients of ours, we wrote comments, and I know a number of environmental groups in the state wrote comments trying to urge DNR to make sure that the full environmental assessment process is available for high-capacity well permit issues. And DNR actually tried to lump CAFO WPDS permits in the same boat by saying it's not significant enough of an action to warrant an EA. So again, we're trying to push them in the opposite direction. So in light of the progress that we've made and the challenges we face, I think we all recognize that we have our work cut out for us, but we have a lot of momentum in terms of the water protections that we have, the statutes and the rules that are already on the books that we just need to leverage leverage them to be more effective. I think the outlook is really bright, and because we have a history of accomplishment in the water quality and water quantity realm, there is a good framework already in place for us to make some progress. Thanks very much. I appreciate being able to speak with you today, and enjoy the rest of your day.